First of all, let me say that to those who are collecting the membership fees later, that I can say as a former jobbing lawyer that lawyers are generally, particularly members of the bar, impecunious, and therefore go easy on them. I have a little bit of a speech difficulty at the moment, so please forgive me in any inability to communicate that this may cause. First of all, let me start by saying that I'm honoured by the presence of so many of you, members of the judiciary. Garrett Fitzgerald, if I may specifically draw attention to his presence. And Garrett I refer to at the outset because for many of us, while some of the issues that I will touch on may be dry, he was the one who, for many of us, inspired a belief in the nobility of European integration, which goes way beyond the desiccated figures that are presented as being the basis and justification for our involvement in Europe. He was one who recognized from the very outset the nobility of a cause which seeks to share sovereignty between states and which seeks in a unique way to create a relationship between states which is grounded in law. Because the fundamental difference between what the European Union is and what all other purported unions claim to be is that the European Union is something which is based upon a principle of shared sovereignty in specific defined areas. Nobody else has ever tried this before, and in 1,000 years of European history there has never been a more noble political ideal than that of sharing sovereignty between states. And what it has achieved, however mundane and banal it may appear to be as an argument today, is the recalibration of relationships between peoples divided for centuries by war and fratricidal war at that. It has brought people from different religious or non-religious backgrounds together, believing in certain fundamental principles and certain rights, many of which, incidentally, are enhanced by the inclusion of the Charter of Human Rights in the treaty, which I will be talking about shortly. And in many ways, Ireland has had a magical association with the European Union. We came in as the poorest country in Europe. For a period until 1981, we were significantly lower in GDP per capita than the average. In fact, we were the lowest. Greece joined in 1981 and Spain and Portugal in 1986. But I would like to think that the fact that we gained more financially than anybody else from Europe, the fact that it brought us into a situation where this small island with a small population, making up no more than 1% today of the total population of the European Union, 1%, has had a seat at the table and an influence on the policies of global events shaped by the European Union itself. Our alternative would have been to float off the west coast of Europe, unlistened to and unknown, with a relationship which was based upon and developed solely out of a bilateral connection with the United Kingdom. And that's as it had always been historically. And the figures testify to the fact that our relationship with the rest of the world has been transformed. When would we have seen a Chancellor of Germany visiting Dublin? When would we have seen the Council, the European Council, taking fundamental decisions in Dublin about the future of Europe? How would we have had an influence, which those of us who've been fortunate enough to do it can testify to, that if you are sitting round a table, the person with the best argument generally wins? The fact that you are representing a country that has a very small part of the population of Europe has been irrelevant. We have had all of the major commissionerships bar one. We've had internal market, we've had competition policy, we have had social affairs, we have had a remarkable impact in a way which is quite surprising to many people. And it's testimony also in a positive way to the perception, leaving aside the results of referenda, the perception of a positive engagement by Europe, by Ireland, in the context of Europe. So I merely make, by way of prefatory remark, the comment that this is about something which is far more important than how much we get, how much we will get out of Europe. It's about the shaping of a world which, in the context particularly of the period following the collapse of the Iron Curtain in 1989, is an interdependent world of an entirely different kind to anything that ever existed before, where relationships, whether it be in the context of global climate change, energy policy, the migration of people, are changing in a way that nobody has ever had to cope with before. And the only way that Europe can play a role in this, let alone Ireland, is by coming together and taking positions that allow us, working together with our colleagues in Europe, to influence global events. Otherwise, they will be determined in capitals elsewhere, Beijing, Washington, or whatever. But let me now refer specifically to the subject which I've been asked to address this evening. There is, I think, unfortunately, evidence of very serious negative effects in terms of the referendum held on the Lisbon Treaty, on the perception of Ireland abroad. This has been testified to in a whole range of different areas, and it's been testified to by a remarkable degree of apparent unanimity from others outside Ireland in terms of the context. I remember in particular reading, and I sought it out and found it, an article by Theo Sommer, who's probably the most distinguished German political correspondent. And he wrote in the German Times, Eurosceptics like to brandish the argument that the Irish vote has to be heeded by all member states, as it is the result of a democratic process. He went on, this raises not only the question whether it is truly democratic for a tiny minority to stop an overwhelming majority from moving forward if they wish to do so. And nobody denies the legal position and the right that Ireland has to vote no. But I would like to look for a moment at some of the arguments and the presentation of those arguments which led to the result which we have now to face. After we voted no, I think it would be fair to say that around Europe, few could understand what we had done, and who could blame them. The likely negative consequences were identified clearly before the vote even took place. They were widely adumbrated in our press and in some commentary that one might have thought was serious about it. It's hardly surprising to me that the result was incomprehensible to many Europeans. After all, even the most self-centred, non-idealistic person looking at it solely from the point of view of self-interest would recognise that Ireland had gained a great deal from its membership of Europe, and that this created a question mark about our commitment to Europe into the future. In economic terms, on a per capita basis, the Irish people had gained far more than any other country in direct financial benefits from the EU. And furthermore, we provided ourselves with a place on the world stage in terms of influencing events which had been extremely important. Without trivializing this or suggesting that we should vote yes out of a sense of gratitude for what had happened in the past, which would clearly be a ridiculous argument to advance, I was reminded of Prince Schwarzenberg of Austria, who, in response to the question put to him in 1845 as to whether he felt indebted to Russia for helping to crush the Hungarian revolt, replied, "Austria will astound the world with the magnitude of its ingratitude." But on a more serious note, this was an amazing result to many because the treaty itself appeared devoid of issues likely to raise serious controversy anywhere else. For me and for many Europeans, far from going too far, the treaty did not go far enough. Apart from this, our entire economic strategy was and is predicated upon European integration and breaking loose from our prior economic dependence on the United Kingdom. Without the completion of the internal market providing for free movement of goods, services, capital and people, we would never have created the 80% of additional jobs in the last 15 years. Most of those were actually in industry, not in the construction industry. And they were largely the result of inward investment into Ireland. As the Minister for Foreign Affairs recently pointed out, the stock of foreign investment in Ireland has increased by 400% since 1993, which was the year of the internal market completion. This clearly could not have happened if we were not in good standing in the EU, and it will not happen in the future if we're seen to be negative to the whole project. So the objective reasons for supporting a project overwhelmingly adopted by the parliaments representing 99% of the population of about 500 million people appeared obvious. No doubt many foreigners asked themselves the question, was Ireland's choice an extension of the type of Euroscepticism so evident in Britain? Had we been persuaded to join those who simply do not wish, in principle, to share sovereignty? Could it be the case that we were therefore rejecting the sharing of sovereignty in principle? This doesn't appear likely. For one thing, any examination of Europol data over the last 10 years establishes absolutely clearly that the Irish people express themselves to be fervent believers in more European integration. This is in direct and dramatic contrast to opinion in the United Kingdom. In fact, on most counts, and I've gone through them, we're the most pro-European of all member states of the EU, whereas the British are the least in favour of the broad concept of European integration. So, if generalised opposition to the European project did not drive the dramatic vote against the treaty, what else did? After all, the Irish people not merely rejected the Lisbon Treaty, they did so in the teeth of the strong advice of all of the political parties, representing over 98% of the representatives in our Dáil. So we have a tiny rump of opposition provided by Sinn Féin and Libertas, who incidentally in significant respects contradict each other, or did during the campaign. But the people rejected their political leadership, and they rejected too the overwhelming support of business and largely that of the trade union movement and ultimately the agricultural lobby, the IFA as well. Before going further, perhaps we should attempt to answer why this happened. Now, there have been a number of surveys conducted. People talk of complexity. They talk of confusion. But they also talk about specific matters. First of all, let me deal with the issue of complexity. This treaty is immensely complex. It's immensely complex of necessity, because if it didn't seek to cover everything in detail, even more absurd interpretations than those which we've been subjected to would have been advanced by its opponents. It could have been reduced to a series of simple statements. But paradoxically, the complexity is the result of attempts to be clear and unambiguous. If it were a document simply containing statements of general description, it would undoubtedly have been attacked as a Trojan horse through which all sorts of alleged mischief would be introduced by the courts, if not by anybody else. It would be argued that the document permitted all sorts of interpretation and that the European Court of Justice would greatly enlarge the competences of the EU institutions beyond those initially intended. Just as we have seen, indeed, under the American Constitution or our own Constitution in terms of judicial activism and the initial intent of those who adopted constitutions. But I'm not arguing as a strict constructionalist here. I'm simply saying that that's why the document was written as it was. After a long convention involving not merely politicians, but also the various social partners, a text was agreed. The complexity, therefore, is inherent in a project that seeks to combine, in an absolutely innovative and unique way, the confederal and the federal, the supranational and the intergovernmental. And it's that mix and the levels at which that mix takes place that makes the European Union what it is. Recognising the difficulty of having a referendum on such a text, particularly for a treaty which in terms of its substance is much less effective in terms of advancing change than either the Maastricht Treaty or the Single European Act, every other state wisely decided that parliamentary democracy should provide the ratification method. All the other 26 member states foresaw the mischief that could be made in a popular debate about a treaty that in reality did little more than necessarily increase the efficiency of the organisation, create new positions like a president of the European Council and a foreign representative, both of whom have to act in effect through the combined will and agreement of the member states. It did increase necessarily some majority voting, but in areas which do not and have not given rise to difficulty elsewhere, and which was a necessary part also of the enlargement to 27, where if you had anything less than majority voting in the areas, you'd have paralysis. The treaty was subject to rigorous debate in all the parliaments of Europe. And at the end of the day, the opposition, virtually everywhere, except across the Irish Sea, was paltry. For example, in that most fractious and divided of parliaments, the Italian parliament, there was not one vote against the treaty. Or, noticing the presence of the Spanish ambassador, Your Excellency, in Spain, there were 6 votes against in the Cortes, only. This is after great debate. One of the great arrogances of some of our commentators has been to suggest that we alone should take this opportunity to, quote, represent the people of Europe who might otherwise have voted no. I find that a most arrogant position to take. People have adopted their constitutions and decided the methodology of their democracy. They have worked it effectively, and they have, in the vast bulk of this continent, reached conclusions overwhelmingly on this treaty. The only headlines after the adoption of the treaty by everybody else were headlines about us. There's been no marches on the streets of Paris, no riots in Rome. There's been no discussion about a treaty which poses no threat to anybody, but which uniquely here was presented as a threatening movement of European integration which would in some way deny the rights and damage the culture of individual states. And there was very little sympathy anywhere for the position that we took in it. Some quarters, undoubtedly in the United Kingdom, cheered what we had done. We had a referendum because of the Crotty judgment and the terms of the Constitution as interpreted. It seems clear that the treaty would have been passed in the first referendum that we had on it if the issues of corporate taxation, neutrality, abortion and conscription had not been introduced as substantive topics. The fact that ridiculous, and I use the word advisedly, arguments without real substance could gain such traction in a national debate after all of our political parties, with the exception of Sinn Féin, described them as having no reality, is a matter of deep concern. But the arguments were repeated ad nauseum during the campaign that threats were posed in these areas. These arguments, in my view, were fully answered if anybody wished to listen to the answers. Either the answers were viewed as being less than adequate, or alternatively they were not properly explained, although this to me is also hard to fathom. For one thing, the fact that there was no threat was fully answered by the political parties, and also by the independent referendum commission under a High Court judge. It was criticised in one respect, but the essence of the argument was never contradicted, where each of those issues was dismissed as being an issue. And it was unambiguously dealt with, although it was presented at the time in the media as if the Electoral Commission, which had come through with this report, was merely a partisan part of the debate, and therefore due no more attention or respect than the parties who were obviously motivated on one side of the debate or the other. There was one substantial issue apart from the ones that I mentioned, and that was the question of every country having its own commissioner. That has now, of course, been changed at our request. The basis for that request was questionable. I personally disagree with it. I would have preferred had it remained as it was, with a rotation, every country having a smaller, having 10 years out of 15 in terms of the rotation membership of the Commission, recognising that commissioners are not representing countries in the first place, and in fact take an oath not to do so. I would have thought it would make the Commission more effective, and I would have thought that those who were giving up sovereignty in that respect were more likely to be seen to be the larger states than us, who would be put in exactly the same position as France, Germany or Spain. But whatever about that, that debate is over. So, hopefully, are all of the other arguments which I have described as having no substance. They've been dealt with in a lucid, clear, well-developed text which the government has put forward and which has been accepted. Everybody in Europe, therefore, have made real and enormous efforts to accommodate to arguments which had been accepted here, which I think virtually, if not all of them, believe did not have substance in the first place. One reason for the public's confusion was the result of the fact that in much of the presentation of this whole issue on RTE and elsewhere, the arguments were treated as if they had equal credibility. If 30 business organisations, which is about the number that came out in favour of the Lisbon Treaty, said that they were in favour of the Lisbon Treaty, it was necessary to produce Mr. X, a businessman, on the main news, often in the key slot, saying that he disagreed. The arguments on the matters that I've described, that were dismissed by every academic or analysts that I'm aware of on the issues that I've referred to, the list, were presented time and time again as being of equal standing to the arguments which were being advanced against them. In addition, practically all of the political parties were constantly crammed into 50% of the airtime, with the other 50% being opened up for the motley collection of those who opposed. This is not the first time this has happened, and it's not the first time that we've had a result like the one that we've had. It was the interpretation of judgments of the Supreme Court that led to this situation. Section 18 of the Broadcasting Act 1960, as amended, requires all broadcasts by RTE to be reported and presented in an objective and impartial manner. Nobody could deny the importance of that restriction, and everyone would agree with it as a requirement. I certainly don't disagree with it. The Coughlin judgment condemned an 80-20 division of airtime for uncontested party political broadcasts on the divorce referendum as being unfair and unlawful. However, more generally, whilst equity is required, one judge, Judge Denham, made it clear that equality is not. Whilst the Chief Justice made reference to holding the scales equally, in current affairs programmes, all that is required, surely, is to be fair having regard to the merits of the case and have a recognition of the balance of arguments and who is making them. This might dictate that each side be given the chance to have its say, or that its position should not be misrepresented. But it should not mean that once one side expresses a view, automatically the other side is allowed to express a contrary view in the same programme, even though that riposte is without foundation, as was the case with the issues that I've identified. So I'm not talking about muzzling debate. There should be no muzzling of debate. I'm not talking about interfering with the impartiality of RTE, which is vital. But I am saying that editorial judgment also requires that we don't create confusion around issues where confusion should not exist. In the event that one side or part of one side of a referendum campaign is making claims that cannot be substantiated in fact or in law, it's not unfair to that side, nor is it partial, to conclude that the claim in question is unsubstantiated and to act accordingly. That is what editorial responsibility is about. I gave an example earlier, an extreme example of a referendum that black was the same as white. The fact that you have such a referendum and that a number of people want to argue the contrary case, or argue that case, doesn't surely mean that there is an obligation on the national broadcaster to give equal credence in terms of the argumentation to something which is palpably wrong, or which has been determined by a referendum commission to be inaccurate. I think that's what editorial responsibility is about. The fact is that by adopting a policy of deference to unjustified arguments, just because they're made in a referendum campaign, there would necessarily be a failure to be fair to the side not making unsubstantiated claims. And Coughlin was concerned with a particularly blatant case of lack of balance. Nothing in the judgment requires what happened during the last referendum campaign in the provision of uncritical coverage to arguments. In addition, I think that there was a trawling of the byways and highways of not merely Ireland, but Europe, to find spokesmen on these issues. These, in some instances from abroad, have been presented here as if they're significant and authoritative political figures. But they weren't. There were some instances, too, where marginal figures on one side or another of the debate here were presented as authoritative figures. when they weren't. This is not a question, therefore, I'm arguing of a balancing act. It's a question which is going to be posed now to the Irish people in the context of the most serious decision that this country has ever taken in international affairs. I believe the last referendum could also have been described before it took place in similar terms. Of course, none of this applies to the print media. Many of the British titles with wide circulation in Ireland have run deliberate, consistent and massive campaigns for no vote. From the beginning to the end, they have done so and are still doing so. Their editorial policy in the United Kingdom has been the same for years. They're vehemently, in many instances, Eurosceptic, and nobody denies their right to be Eurosceptic. But balance has to be found in respect of specific arguments which are invalid. Nobody argues against those who would go on television and argue against the sharing of sovereignty, and would argue for pure national sovereignty. I quite accept those arguments. What I find unacceptable is the bolstering of specific arguments which have no substance, like the ones I mentioned. Another judgment that hasn't helped, incidentally, is that of McKenna and Taoiseach, number 2. In that case, the majority held that expenditure of public funds on one side of a referendum campaign breached the constitutional right to equality. This judgment has not been interpreted merely as inhibiting, but actually as precluding the government from spending state funding advocating a yes vote in any referendum proposed by the government elected by the people. I don't know of any other country in the world with such a prohibition. I think it is unheard of that a government is not allowed to advocate, elected by its people, the case that it believes in the massive national interest as a government, not just as a political party. Judge Barrington in the Hannafin, the Minister for the Environment, made the point, I quote, "The government is not merely the chairman of a debating society." I'm inclined to agree with them, and I hope you are too. He also said that politicians who think that the Constitution should be amended have the right and duty to attempt to persuade their fellow citizens to adopt the proposed amendment, and it appears to me that they're entitled to do this individually, as private citizens, or collectively as members of a government. I don't think that a government in a democratic state should be restricted as it is in Ireland, and an opportunity will not be found to address the issues, some of the issues that I have mentioned in this address before the forthcoming referendum. So I appreciate that I'm not arguing for change in regard to this referendum, but I am pointing out the dangers of some of the situations that we've allowed ourselves to drift into, and in time they should be dealt with. It's worth bearing in mind that we've had numerous referenda on the EU treaties. Who even now remembers the points that were made so strongly, with such vehemence and such stridency, by those who opposed the Single European Act, the Maastricht Treaty, the Nice Treaty? Who remembers? What were they? What was wrong with the Single European Act? What was the European Single Act? What was it all about? Who knows? But at the time, our people had been provoked to a state of extreme anxiety by the presentation of arguments without validity. And that's why I link public debate, the courts for the reasons that I've described, and the issues of this particular referendum at this time. Is it easier just to duck this particular issue? Because one can imagine the answers and suggestions of muzzling, which nobody is talking about. No, it's not time to duck issues of this kind. It's time to deal with it. Perhaps that's what people thought the last time, before we took a step which many of us deeply regret in terms of its effect on Ireland. How is it therefore, that all the dire forecasts that we've been told about in the past have never come to pass. How is it that it's the exact same people who are advancing the arguments about dire circumstances and forecasts in this instance? Some of the arguments are even surfacing again. It pains me so much that I won't even mention one of them that came up in a letter to the editor of one of our newspapers this week, but I will. The argument that foreign direct investment would be interfered with. This old cadar is being raised again by this treaty. Absolute nonsense. Absolute nonsense as demonstrated by Article 188C4, if anyone wants to read it, which clearly states the position as it is. It's very good to see an engagement by lawyers, at least in being prepared to put up with listening to my meandering diatribes on a Friday evening. Because whilst there have been individual involvements in earlier debates, they haven't been often, and some of them have been extremely effective and useful, they haven't always had a weight of opinion. We've seen lawyers writing in large numbers to newspapers recently on another matter, but it seems that the Lisbon Treaty has not acquired quite the same importance. Let me conclude with a quotation from Der Spiegel. Democracy doesn't assume unlimited confidence in the citizenry. Sometimes great matters are better in the hands of politicians. Well, that may be true, but whether it's true or it's false, we are where we are. We have a referendum, and we have a referendum that we have to win. Because this time, in my opinion, if we lose this referendum in the teeth of the adoption by everybody else in Europe of the Treaty of Lisbon, we will have an unanswerable moral issue to answer about what we do next. To me, the only honourable thing to do would be, in one way or another, to step aside. To think that we can hold up the march of Europe in this context is living in a fairyland. I noted the former Secretary General of the Commission making the comment, ambiguous, deliberately I've no doubt, that we would become a non-player, one way or the other, whether in the more dramatic scenario that I've painted or otherwise. That's exactly what we would become. And for me, as a passionate Irishman and a passionate European, that is unacceptable. Thank you very much indeed.